Colleagues and friends, we're going to request that you switch off your phones or you keep them on silent because we don't want to make that request when court is in session. Please do that now. Is there anyone in the audience who can sing well? We need someone to lead us with the national anthem because sound is not able to do that for us. Not now, but not now. Because in any way you would not be singing it seated anyway. So we'll be that you can sing. Okay. You are the person.
calling them. I'm calling them.
In the matter between Rose Mudau and Samuel versus Denga SGB in their high school, the court is now in session. You may be seated.
As we commence the program this morning, I'd like to request all of us to stand for the singing of the National Anthem, which will be followed by the recital of the preamble of the Constitution. May we all stand? Shall we remain standing so that Avuzwa from Mthatha High School in Eastern Cape can lead us with the recital of the preamble of the Constitution? Avuzwa.
We, the people of South Africa, recognize the injustices of our past. Honor those who suffered for our justice and freedom in our land. Respect those who worked to build and develop our country. And believe that South Africa belongs to all who believe in it, united in our diversity.
And believe that South Africa belongs to all who believe in it, united in our diversity.
We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic. We therefore, through our freely elected representatives, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundations of the past and establish a society based on for a democratic and open society in which government is based on the will of the people and every citizen equally protected by the law. Improve the quality of life for all the citizens and free the potential for each person. Improve the quality of life of all citizens and free the potential of each person. And build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people. May God protect our people. Nkosi sikelela iAfrika. Nkosi sikelela iAfrika. Morena boloka setjhaba sa heso. Morena boloka setjhaba sa heso. God seën South Africa. God seën South Africa. God bless South Africa. God bless South Africa. Mudzimo fatuchedza South Africa. Hosi katekisa Africa. Hosi katekisa Africa. Thank you.
You may be seated. Deputy Minister, Chief Justice, and the whole panel of judges, officials, parents, teachers, caregivers, learners, everybody who's here, we greet you this morning and thank you for taking the time on such a beautiful Sunday morning. Some of us would have been in bed still, but it's important that we're here. At this stage then, I would like to request the Commissioner, Advocate Andre Gom, to render a welcome and opening address.
Thank you very much and good morning to everyone. Greetings to our presiding judge, Judge Jody Kulapan, Judge of the Constitutional Court, judges of the High Court, Deputy Minister John Jeffrey, the Deputy Minister of Justice and Constitutional Development, Dr. Mohaule, the Deputy Minister of Basic Education, cannot be here today, but she's also been very involved in this whole process, and we thank her for that. Professor Frans Viljoen, the Director of the Center for Human Rights, University of Pretoria, Ms. Chantal Kisoon, the CEO at the South African Human Rights Commission. Good morning also to officials from the South African Human Rights Commission, the Department of Basic Education, and the Department of Justice and Constitutional Development, all partners in this important Moot Court project. And good morning to all participants, particularly the learners and the teachers, and a happy Teachers Month to all our teachers. Today marks the end of the 2022 National Schools Moot Court program and the beginning of a life of learning for the many participants of this competition. Although my role needed to maintain high academic performance and maintain some level of discipline. It is through this program that learners are able to weigh the values espoused by the Constitution and interact with other lawyers, all in the spirit of teaching and learning. All this happens under the watchful eyes of skillful teachers and lawyers who assist from the essay writing levels up until the provincial and final rounds, the final round we have here today. And we are thankful to every individual and organization that have assisted the learners to reach this moment today. The program intentionally draws participants from all walks of life, including from the most rural village in Vosburg in the Northern Cape to the most modern school in Sandton in Gauteng. There is only one constitution and one Bill of Rights under which we all are bound and we all enjoy the protections afforded by it. This is important as this Moot Court program speaks to how our constitution seeks to protect everyone who lives in South Africa, particularly the marginalized and indigent. The legacy of this program will not only be how many students it has touched and assisted in making the right choices in terms of higher learning or career choices, but it will also be how far and wide it reached to young South Africans. Its legacy will be how many young South Africans it has conscientized and sensitized about human rights and the protections afforded by the Constitution to their fellow learners and their communities. With these few words, I welcome you all and welcome the justices of the court to the final round of the 2022 National Schools Moot Court program and the beginning of many careers in law and human rights. May we all enjoy this day and undertake to live the preamble of the Constitution as we head back to our communities. Thank you very much.
A round of applause, please. It's not yet time for the Chief Justice, so you can be free until he takes the stand. Then thereafter you can be as stiff as you want to be. And I also forgot to indicate that this session is being live streamed on all our social media platforms, lest I infringe the POPI Act, Advocate Commissioner Gaum, just so you know that what you've just delivered now has been streamed live on social media and the rest of the session that we're going to have today. We are going to be receiving a special address from our Honorable Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, who is a staunch supporter for this program. Over to you, Deputy Minister.
Thanks very much. In terms of the separation of powers, I don't usually stand or sit up here. But just the court doesn't really lend itself to speeches from the side. But Program Director, esteemed judges present, commissioners and officials from the South African Human Rights Commission, officials from various government departments and from the Centre for Human Rights at the University of Pretoria, and more importantly, the learners, their families, and their chaperones. This event is one which is particularly close to my heart, and one which I'm always honored to be able to attend. As you may know, the first annual National Schools Moot competition took place here at the Constitutional Court on Human Rights Day, the 21st of March, 2011. At that time, event teams from 4 schools in each of the 9 provinces were selected to participate in this groundbreaking event. Since then, the competition has gone from strength to strength and has produced some remarkable achievements. For 3 years, the winners of the competition here have gone on to the International Schools Moot and have won it, the last time being in 2020. The National Schools Moot program is a collaborative effort between a number of role players, and I think I can say on behalf of all of us that we're extremely proud of the program and what it has achieved over the many years. We believe that for South Africa to thrive as a constitutional democracy, it's fundamental that learners in all our schools know their constitutional rights. Human rights awareness is vital as it contributes to a society which is based on freedom, human dignity, and equality. One of the main aims of this program is to give learners the opportunity to explore various sections of the Bill of Rights and also to develop their own writing and oratory skills and talents. Schools and our young people are often catalysts for social change, and this program therefore becomes relevant in instilling and educating young people, and thus also broader society, on constitutional values, human rights, and active citizenry. I'm particularly pleased that this final is currently being live streamed on various platforms. I'm sure there are many learners currently watching these proceedings, and that your participation here today will inspire them to also participate in this competition in future years. The 2020 National Schools Moot Court program began earlier this year with grade 10 and 11 learners writing an essay which delves into the scenario taking place at Denga High School. The school is experiencing a high number of unplanned pregnancies, which has resulted in female learners dropping out of school. Of course, if we look at real life here in South Africa, learners are indeed dropping out of school, not only due to teenage pregnancy, but also due to other factors. I want to share with you the findings recently released by Stats SA in June this year. And these findings show that last year, 2021, nearly 9% of 17-year-olds dropped out of school. Statistics South Africa's General Household Survey indicates that although most 18 and 19-year-olds were still attending secondary school, almost 3 out of 10 learners aged 18 and 4 out of 9 19-year-olds had dropped out of school. The most prominent reasons for non-attendance at school include illness and disability, that's 22%, poor academic performance, close behind at 21%, lack of money for fees at 19%. Reasons for dropping out of school differ by gender, especially for girls who have to stop attending school due to family commitments, that's 13%, while close to 5% of males of boys stopped attending because, quote, they had no interest in education. The school dropout rate is of particular concern because students who drop out of school prematurely experience a lack of access to higher education, fewer job opportunities, and lower wages than their peers who finish their schooling. School attendance is extremely important, and that is one of the reasons why the Department of Basic Education launched its new policy on the management and prevention of learner pregnancy in schools towards the end of last year. I won't say too much about the details of the policy, as I'm sure many of you will be referring to it in your oral arguments shortly, but just to highlight that the policy affirms the right of a pregnant learner to remain in school during her pregnancy and to return as soon after giving birth as is appropriate for both the learner and her child. The school is also required to reasonably accommodate the learner to ensure that her right of education is not negatively affected. Pregnancy is but one of the factors which can have an impact on the constitutional rights of learners. Here we also think of bullying, both in person and online, and the impact that it has on learners in their daily lives, and how this infringes on their rights to human dignity and equality. We also know that, for example, lesbian, gay, bisexual, transgender, intersex, and queer learners face serious challenges of discrimination and prejudice in schools and in their communities. I want to specifically mention 3 school learners who have tragically taken their own lives after allegedly being bullied for their sexual orientation. According to media reports, Lucanyo Jongo, who was 14 from Stutterheim, and Tiro Moalusi, 15 from Soweto, both committed suicide after allegedly being bullied by teachers. Mpo Falitenjwa, who was 14 from Orange Farm, also took his own life after being bullied because of his sexuality. So we must ensure the safety and inclusion of all learners in our schools and ensure that their human rights are protected. To the learners here today, I've been following some of the clips on social media, and I'm extremely impressed with the quality and the high standard of what we've seen so far. I want to commend and congratulate those who've made it through the various provincial rounds, as well as those in the national finals which commenced on Thursday. To the finalists that are here, best of luck, and we look forward to seeing your oratory skills and your understanding of both the Bill of Rights and human rights generally. To each and every learner who participated, congratulations on what you've already achieved in this competition. You yourselves, your schools, and your families can be extremely proud of you. I know that in a few years from now, some of you will be appearing before this court as legal practitioners. For those of you who plan to embark on studying law, there's a saying in legal circles that many candidate attorneys are taught, namely, and I quote, if you can't convince them, confuse them. However, I can unfortunately assure you from personal experience that that doesn't work. So to the finalists, take note of that as well. I want to wish you all of the best for your school career and for your future studies. You've been given a talent. Harness that talent and use it towards the greater good of society and to help build a better world. And I'd just like to close with words from late President Mandela, who said, "A good head and a good heart are always a formidable combination. But when you add to that a literate tongue or pen, then you have something very special." Thank you.
Thank you so much, Deputy Minister. Without now wasting time, I also just need to mention that we are on Newsroom Africa. I'm not sure if they are live, but I'm told that they're coming in and out of this court to take some live snippets from the sessions, or from the session that we have today. So we thank you, Mr. Mhlanga, for advocating and for just putting us on the map and making sure that there's advocacy and communication about this program. I'm now going to cease from the stand, and as I cease, I'm going to hand over now to the bailiff, Ms. Rohula Bilankulu, who is going to now take us through how we are going to proceed. She's also going to introduce the panel of judges, and then thereafter I will come back only after the judges have announced the winner, so that we can then consolidate the session for this morning. Thank you. Rohula?
Let us all rise to start our session. In the matter before this honorable court, the matter of Rose Mudau, Samuel Muloko, versus the school governing body of Denga Secondary School, this court being officially in session, we have Chief Justice Kolapin presiding, alongside Justice Sophia, with Justice Caitlin, Justice Victor, Justice Skelton, Justice Rea, Justice Cassette, Justice Sivanyoni, and Justice Guam. This court is officially in session. You may be seated. The applicants, we are ready when you are.
My honorable justices, my name is Amahle Ngubane, and I appear on behalf of the applicants with my co-counsel, JC Francis. For the next 8 minutes, I will be addressing the issue concerning the unconstitutionality of Section 6.3.4 of the Respondent's Pregnancy Policy. My co-counsel will then address the issue of the violation of the first applicant, which is Rose's right to privacy and unlawfulness of her suspension for 10 minutes. We respectfully reserve 2 minutes for rebuttal. In turning to my submission, we submit that Section 6.3.4 of the Respondent's Pregnancy Policy is unconstitutional on these following grounds. Firstly, it violates Section 9 of the Constitution. Secondly, it violates the right to dignity. Thirdly, it violates the right to privacy and the right to found a family. In turning to the first ground, which is the violation of Section 9. Section 9 of the Constitution provides that everyone has equal treatment before the law. Section 6.3.4 of the Respondent's Policy violates the rights on 2 grounds. Firstly, it discriminates against learners on the basis of gender. Secondly, it discriminates against learners on the basis of pregnancy. In turning to the first ground, we submit, under Section 9, we submit that Section 6.3.4 of the Respondent's policy unfairly discriminates against male learners because male learners in similar circumstances to the first applicants, which is Rose, would not be required to disclose the identities of the women they impregnated so that these women could account to instances of sexual violence, coercion, or statutory rape. Accordingly, this shortfall would not be in the best interest of these children. On the grounds of pregnancy, this section also discriminates against learners on the basis of pregnancy, as the policy does not extend protection to vulnerable girls who are sexually violated but not yet pregnant. Based on these two grounds, we submit that the policy violates Section 9, Subsection 3, and that discrimination is unfair. On the basis of dignity, the Respondent's pregnancy policy is unconstitutional as it violates Section 10 of the Constitution, which is the right to dignity, which states that everyone has an inherent right to have their dignity protected. As the first applicant is a student, she is likely to be judged when disclosing the identity of the father and stigmatized on dating an older man who in this case is a bus driver and being pregnant at a young age. In the case of Teddy Bear Clinic, in the case of Teddy Bear Clinic versus Minister of Justice, in paragraph 52 states that dignity recognizes the inherent worth of all individuals, including children, as members of our society, as well as the value of the choice they make. Teenage pregnancy is already deemed negative by society, and by instituting this legal process, hence prolonging the applicant's case, the respondents hence directly encourage her further stigmatization and further being judged by society.
Ms. Ngubane, the idea of having a policy to deal with pregnancy at school appears to, if one looks at the policy, directed towards providing counseling, protecting the learner who's pregnant, and if the person responsible for the pregnancy is also a learner, counseling that person. So is that not an objective that is positive in terms of learners' rights and in terms of their right to education?
As the court pleases, may Chief Justice please rephrase the question.
Okay, it seems that when one reads the policy, the idea behind the policy is to protect both learners if both of them were responsible for the pregnancy through counseling and not through their suspension. And this part of the policy that we're dealing with today relates to persons outside of the education system. So I'm trying to understand what is wrong with the policy if it has that objective. Do you follow my question? Yes.
As the court pleases, my Chief Justice, what is wrong with this policy in this instance is that it violates the rights of the learners in reference to dignity, as per Section 10 of the Constitution.
Could I just quickly ask, just in relation to that, perhaps it might be useful if you could assist us by pointing to which bits of the policy. Is it the whole policy that you say violates the dignity, or are there specific aspects of it that do? Thank you. You understand the question?
Yes.
Thank you.
As the court pleases, my justice, it is the whole policy because in this instance, it forces the applicants to reveal the identity of the father, which then in this instance violates their privacy. When proceeding to privacy...
Sorry, Ms. Ngubane. Commissioner Gom, do you have a question?
Yes, my question would be, is it the policy that is unconstitutional, or isn't it the application perhaps of the policy that is been wrong, and therefore that is unconstitutional. Because if you look at the policy, it says that if the biological father is a person outside the system, he too should be subjected to judicial inquiry and action if there is a case to answer. It doesn't appear that there was a case to answer here on the grounds of coercion, sexual violence, and assault or statutory rape. So is it the policy that is the problem, or the application here of the policy, perhaps?
As the court pleases, we as counsel for the applicant submit that it is both the policy that is wrong and the application of the policy. Because in this case, the manner that the respondents infringed on the applicant's right to privacy, and it discriminates against the learner's rights. In relation to the right to found a family, we submit that Section 6.3.4 of the respondent's policy violates the right to privacy on the basis that it does not contain sufficient procedural safeguards to relate how the information relating the identity of the father should be processed. In instances such as this one, in instances such as the one in this case, nothing prevents the school from unduly disseminating information regarding the instance of a judicial inquiry with third parties. Particular to this case, this equally violates the right to found a family, as disseminating such information places the second applicant's job, which is SEMO, at risk, unduly so. If this court pleases, I will now hand over to my co-counsel to address the issue of privacy and suspension.
Thank you, Ms. Ngubane. Ms. Francis?
As it pleases the court, I am Jessie Francis, and I will now further be elaborating on the applicant's case. The second applicant is on the basis that the respondent violated their right to privacy. Section 14 of the Constitution states that everyone has the right to privacy, which includes the right to not have their privacy or communications infringed. We submit that by the respondent going through Rose, the first applicant's personal conversations, is a direct violation of the first applicant's constitutional right to privacy on these three grounds. 1. Rose had a legitimate expectation of privacy through the counseling. 2. The processing of personal information was in contrary to Section 11, Subsection 1, Paragraph A of the POPI Act. And 3. There were in fact less restrictive means to acquire such information about the identity of the father. On the basis of expectation of privacy, the respondent unjustifiably violated Rose's expectation on privacy on the basis that, by leaving her personal phone, no one would have the right to go through it without her full consent. The actions of Ms. Moshapa, a member employed by the educational institution, amounted to an act of wrongful intrusion in the breach of Rose's expectation of privacy. In the court in Bernstein versus Bester, at paragraph 69, it states that held that the acts of wrongful intrusion includes the reading of private information, and in this aspect can be extended into our case. The respondent might submit that Ms. Moshapa's actions were justified because they pursued a legitimate public interest. We submit that an honest assessment of her intention when searching the cell phone displays that she was not acting in the public interest. Ms. Moshapa has a notable reputation in engaging in gossip. This was evident when she went through Rose's phone for the sole intention of satisfying her gossiping tendencies and not necessarily searching ideally for Samuel's
Sorry, Ms.
identity.
Francis, can I ask you briefly? So if Ms. Moshapa was not a gossiper, but had good intentions, would that make a difference?
No, that would not make a difference because it's still a clear breach on privacy as she went through the phone during a counseling session.
And then just a second question. Let's assume that Rose was not in a relationship with Samuel where they had mutual feelings for each other, but that she was in a relationship with an educator who forced her into this relationship, and she was reluctant to divulge this because the educator had promised her that she would fail. And the school suspected this. Would that make a difference? Because then the school would say, well, we're concerned about Rose, and that's the reason we went into her private messages in order to protect her, because she would never divulge this information. Would that make a difference to the lawfulness of the search?
As it pleases the court, we as counsel for the applicant would like to submit that if Rose had to partake in sexual relations with a teacher which is in the basic education, it would still not justify the reason for violating her right to privacy, but we would understand the cause for concern of checking such information, but not through this means of violation.
Okay, thank you.
We would like to bring this Honourable Court's attention to the Poppy Act violation. The Protection of Personal Information Act states that you can only process information with the consent of the data subject, nor was it in line with Section 11, Subsection 1A of the Poppy Act, in which only allows the processing of the information if it is in the legitimate interest of the data subject. But as previously confirmed, the core intention of the respondent was not in the best interest of the learner. Furthermore, according to the Poppy Act, personal information needs to be processed legally in a manner that does not oppose to the need for the right of privacy. In this case, the first applicant, being the data subject, has not given her free consent for Ms. Moshapa to go through her personal belongings. Therefore, whereas the counsel for the applicant submit that this is a direct violation of her right to privacy. We submit that the respondent could have considered less restrictive means to acquire such information regarding
Counsel?
Samuel's identity.
Can I just ask a question? Is there a balancing exercise that perhaps needs to take place here? What if potentially, let's assume there had been coercion or some practice which constituted undue influence? Is there not a concern that other learners may be at risk, and that for this reason it's important for the school to find out the identity of the father?
We understand that the school's main objective, one of their main objectives, is to ensure the safety and protection of the children. However, the manner in which the counseling, we can improve the managing of the counseling by maybe sticking to the main objective of counseling, and maybe after mutual trust is built within the counseling session, they will be notified and notice clear stance of fear or objection to reveal their personal information. The first restrictive means would be the school could have consulted Rose's parents, as she stated that the parents were aware of the relationship and hence it was consensual. 2, contact the second applicant with regards to the suspension and the rumors, as he is an adult. 3, as well as the respondent sticking to the main objectives of providing fair and constructive counseling to eventually build a mutual spirit of respect, where she should freely state this information. With regards to suspension, in turning to our submissions,
Sorry,
the aspects...
Ms. Francis, may I just stop you for a moment? You say that the interactions were consensual, and Rose is below the age of 18. Can people below the age of 18 consent to sexual intercourse?
The age of consent in South Africa is 16, so yes,
Thank you, Ms.
can.
Francis.
Okay. Rose was not
Maybe
obligated...
Mrs. Francis, when you're still there,
Sorry?
when you're still there, it would appear Rose became pregnant somewhere in November, and then only in January it was discovered that she's pregnant. In other words, it would appear she conceived when she was 16. We're dealing with a victim who is 17 years old, who it has been discovered she's pregnant. So she conceived somewhere before she became 17. What would be your response?
As it pleases the court, we as the counsel for the applicant feel as though November is at the end of the academic school year, and since the date of birth of the applicant was not disclosed, we are not sure whether the child is conceived. Therefore, we submit that it was by the age of 16, the legal consent age, as it was towards the end of the academic school year. Okay.
So you're taking the facts as they're given, you're not glossing them or making any assumptions?
Yes, no assumptions.
Thank you.
The Denga School pregnancy policy only cites that the identity of the father must be paid close attention to, not that the identity of the father must be disclosed. Therefore, it was unlawful to suspend our applicant for alleged misconduct that was not in line with the Code of Conduct. As it pleases the court.
You may continue for another minute or so. Do you need another minute?
Yes, please.
Okay.
Justice.
You asked so nicely, I'll have to give it to you.
Okay. In the case of Head of Department versus Valcom High School, the court stated that in terms of Section 9.1 of the Schools Act, the school governing body's power to suspend a learner is limited to cases in which a learner is suspected of serious misconduct, and in respect of whom disciplinary proceedings are then contemplated. Through a disciplinary hearing, though a disciplinary hearing is pending, her actions cannot be considered as serious misconduct, as it was not in the policy to disclose this information initially. And based on these facts, the respondent violated Rose's right to freedom of association as well as her right to education, as the suspension was not in her best interests. The matric academic year as well as the FET phase consists of strenuous as well as heavy content with a small amount of time. Therefore, our applicant was required to catch up on all this information through an important time in her academic career. To summarize, the counsel of the applicant strongly believes that the respondent had no grounds to suspend or pry into the personal affairs of the student.
Ms. Francis, can I ask a question, please?
Yes, you may.
There's a problem of pregnancy in that school. There are there's a high percentage of pregnancies. By having Rose pregnant at school, wouldn't that encourage other girl learners to feel free to not be careful and to know that they could still be at school under these circumstances?
As it pleases the court, the main objective of this policy is to ensure that all pregnant learners are able to obtain their education throughout their pregnancy. Therefore, we are saying that Rose's case in this instance is different to other cases as it was consensual.
Ms. Francis, are you about to wrap up or have you wrapped up?
Can I just do my prayers, please, Honorable Justices?
Sorry?
My prayers, call for prayers.
Okay.
The counsel for the applicant respectfully requests that this Honourable Court 1 to declare that the decision made by the High Court was incorrect, as Section 6.3.4 of the Denga School Pregnancy Policy is highly unconstitutional, and that the unlawful search of the applicant's cell phone and the decisions made with regard to the findings and processing of this information directly violates the applicant's right to privacy, as well as 2, to inevitably conclude that the acts taken by the respondent were inappropriate and unjust, which lead to the applicant's violation of freedom of association and education. Respectfully submitted. Counsel for the applicant. Thank you, Honourable Justices.
Thank you, Ms. Francis. Good. Are the respondents ready? Is it Ms. Mukandelere?
Greetings to the Honorable Bench. I am Advocate Muthapuli and this is my co-counsel, Advocate Boy. In the case between Rose Mudau and Samuel Muloko versus Denga High School, we are appearing on behalf of the respondents on this Honorable Court to bring forth to the House its largest capacity. My Justices, I will be using the
Sorry,
first...
Counsel. I know you have limited time, but if you wanted to speak a bit slower, that would be fine, and we would take that into account in your time. I know you're worried about getting through the time. Okay. Good.
My Justices,
And relax. Don't worry. Today the cells are closed. It's Sunday, so no one's going to go into the cells.
My Justices, I will be using the first 10 minutes. My co-counsel will be using the next 10 minutes, which sum up to 20 minutes of our submission. Your Justices, counsel for the respondent submit that Section 6.3.4 of the Denga School Pregnancy Policy is constitutional. My second argument is that The search of the cell phone and processing of such information does not violate the learner's right to privacy in terms of the Constitution. My co-counsel will further submit that the school's decision to suspend Rose is constitutional and does not violate the learner's right to a basic education and freedom of association. Your Justices, counsels for the respondent submit that it is important to note that Section 6.3.4 of the Denga School Pregnancy Policy is identical to the Department of Basic Education on management and prevention of learner pregnancy in schools. And the Denga School Pregnancy Policy has a legislation proving that it is constitutional. My Justices, Section 6.3.4 of the Denga School Pregnancy Policy is in line and consistent with Section 28, Subsection 2 of the Constitution, which states that the best interests of a child are of paramount importance in every matter concerning a child. My Justices, in Casio, this policy was legislated in terms of Section 8, Subsection 1 of the South African Schools Act number 84 of 1996, which states that subject to this act and any applicable provincial law, a governing body of a public school must adopt a code of conduct. For the learners after consultation with learners, educators, and parents of the school. This section aims to have a positive impact and aim on children, and also aims to protect learners' rights. My Justices, before admission of learners into the schools, learners and parents have to sign a code of conduct. Counsels for the respondent submit that this gives assurance that Rose and her parents have read and signed the code of conduct and gives consent to complying with it. Furthermore, the Department of Basic Education on management and prevention of learner pregnancy in schools is justifiable as it was stipulated by the High Court, stating that the policy is justifiable in terms of the Constitution. Your Justices, if it pleases the Court, I would like to refer the Court's attention to Section 8, Subsection 4 of the South African Schools Act number 84 of 1996, as it states that nothing in this Act exempts a learner from the obligations to comply with the code of conduct of the school by such learner. Justices, nothing in this Act...
Sorry, Ms. Mukandeleli, I just want to check with you whether you're saying because the policy and the code of conduct is made in terms of a law, and because Rose and her parents read it and signed it, then that's the end of the matter. Is that your argument?
Will you please rephrase the question, my Justices?
Are you saying because this policy was made in terms of legislation, and because Rose and her parents read it and signed it, they're bound by it, and therefore they cannot complain about it?
My Justices, as the Court pleases, they cannot complain about it because Ms. Mashapa is a local-in parent, so she has the right, so she had the right to limit Rose's right to privacy because the limitation was justifiable, and the purpose of the limitation was to see if there is a case to answer on the grounds of coercion, rape, or sexual violence.
May I follow up with you, counsel, on that? If somebody had raped her, then she wouldn't be the one that was breaking the code. So what violation of the code would she have, what would make it justifiable to breach her privacy, if you see what I mean? Because she didn't break any of the school's code of conduct rules.
As the Court pleases, Rose Mudau violated Section 6.3.4 Rose Mudau violated Section 6.3.4 by not revealing the identity of her unborn child, and this request was in terms of Section 6.3.4 of the Denga School Pregnancy Policy, as the Court pleases.
Counsel?
Sorry, I think Judge Victor had a question, but I just wanted to ask okay, doesn't matter. And then Judge Kitley after that, okay.
Thank you, Counsel. You seem very familiar with clause 6.3.4. I want to take you to the last part of that clause, where a person outside of the basic education system can be interrogated or questioned by the school board. What right does the school board have to question someone outside of the jurisdiction of the basic education system?
Will you please elaborate, Justice?
Right. The last part of Article 6.3.4, it says, and this is a constitutional attack on this clause. If you look at the last part, what right does the school board or the teachers have to question someone outside of the system? Like Samuel in this case was completely outside of the system. What is the right or the jurisdiction to question someone outside of the basic education system?
As the court pleases, we must bear in mind that Rose Modrao is a 17-year-old grade 12 learner, and in South Africa, she is regarded as a minor. So when Ms. Masha, when the respondents questioned Samuel, they wanted to know if there is a case to answer on the grounds of sexual violence or rape, as Rose Modrao is still a minor. As the court pleases.
So you see, the question was that legally, what gives them the right to do that? So can a school principal, for example, school principal is not a police authority, for example. What gives the school the authority to question someone outside of the education system? Do you want to consider that? Because that I think was the question from Justice Victor.
As the court pleases, the respondents are Rose's legal guardian, so they had the right to do that, as the court pleases.
Okay, and then I'll come to you.
I know you've got limited time. I just wondered if you look at because the whole focus of your submission has been obviously around 6.3.4 of the policy. Where in that policy does it give the school the right to extract the identity of the biological father from Rose? Where in that policy can we read that she has agreed to give up that information when asked, and that if she doesn't, she's breached that policy? Do you understand my question?
I don't, Justice.
Let me give... What in the policy places an obligation on Rose to answer a question by the school as to who is the father?
As the court pleases, Section 6, we must bear in mind that Section 6.3.4 is identical to the Department of Basic Education on management.
I'm asking you to look at that section and to tell me from looking at it, where does it say to Rose that you must tell us when we ask who the father is? If you look at how it's written.
Counsel, maybe the judge is giving you a clue to look at the wording of the policy that you are defending and answer the question having looked at the actual policy. Do you want to do that? Do you have it?
That's fine.
Okay.
Your Justices, as the court pleases, I'd like to refer the court's attention to Section 8, Subsection 4 of the Code of Conduct of the South African Schools Act number 84 of 1996, which states that nothing in this act exempts a learner from obligations to comply with the Code of Conduct of the school attended by such learner. Justices, nothing in this act exempts a learner who is Rose from complying with the policy. My second submission is that the search of the cell phone and processing of such information does not violate the learner's right to privacy in terms of the Constitution. My Justices.
Okay. I think there would, okay, but I think there were two questions. Are you okay? Yeah. Andre, Judge Gom?
Yes, thank you. Once again, if we look at 6.3.4 of the policy, and you say that that has been violated, it is difficult to understand how that has been violated, because it says that the identity of the biological father only come under consideration in certain instances, and that is where there's a case to answer on the grounds of coercion, sexual violence, and assault or statutory rape. Now, on the facts of this particular case, it doesn't appear that there's a case to answer on those grounds. So I still find it a bit difficult to understand how she has acted in contradiction to 6.3.4. Can you perhaps explain that a bit better?
Justices, can you please elaborate?
No, you indicate that she acted in contradiction with 6.3.4. She violated 6.3.4 of the school policy. But if you look at that provision, then it seems that the identity of the biological father only becomes important where there's a case to answer on the grounds of coercion, sexual violence, assault, or statutory rape. Now, on the facts of this particular case, these factors didn't seem to play a role. So why exactly are you saying that she actually violated 6.3.4 as the principal and the SGB are saying on which they based the decision to suspend her?
As the court pleases, Section 6.3.4 of the Denga School Pregnancy Policy states that if the biological father is a person outside the basic education system, he too should be subjected to a judicial inquiry and action if there is a case to answer on the grounds of coercion, sexual violence, assault, or statutory rape. Ms. Mashapa wanted to know if there is no case to. The respondents wanted to know if there is a case to answer on the grounds of sexual violence and coercion. As the court pleases.
Okay, so your answer is that they had to invade a privacy and look into a phone to establish if there was a case to answer.
As the court pleases.
If one of those four grounds were satisfied, that was the purpose.
As the court pleases.
Okay. I'm not sure how much of time they say you have to stop it, but we've asked you quite a few questions. So if you want to take another minute or two to wind up.
As the court pleases, I mind. As the court pleases, the first applicant, who is Rose, was given a platform to reveal information that was going to help to ensure that the policy was followed. The search of Rose's personal cell phone was not a violation of her privacy, but rather there was a limitation, but rather there was a justifiable reason and purpose to the right of privacy, taking into consideration the limitation and its purpose in terms of Section 36, Subsection 1, Paragraph B, which is the importance of the purpose of the limitation. The purpose of this limitation was only to make sure if it is not sexual violence, rape, and coercion. The best interests of Rose are of paramount importance in every matter concerning a child, in terms of Section 28, Subsection 2. Her best interest that she is not a victim of danger, like rape or sexual violence. Ms. Mashapa is a parent in loco. She has the primary consent to make decisions as a parent to a child in Rose's absence. Ms. Mashapa's actions was to make sure that the school is in awareness of Rose's father of her unborn child, as Rose has refused to disclose such information. Ms. Mashapa's actions were to make sure that Rose complied with the school pregnancy policy. I submit again, my justices, Rose is not exempt from complying with the policy. Can I take my leave?
Thank you, counsel.
As it pleases the court. Justices, I confirm my appearance on behalf of the respondent. We are brought here today by the applicant on argument that the school has acted unlawfully and that its actions were unconstitutional on the basis that they violated the applicant's rights to freedom of association and education in terms of the South African Constitution. We, as the counsel for the respondent, respectfully submit to this court that the school's decision to suspend the applicant was not unconstitutional and that it did not violate the applicant's rights to freedom of association and education in terms of the Constitution.
Firstly, I'd like to bring the court's attention to Section 28, Subsection 2 of the Constitution, which states that a child's best interests are of paramount importance in all matters concerning the child. Justices, we as the counsel for the respondent submit to this court that the school's decision to suspend the applicant was in her best interest. Now, my justices, I'd like to bring it to the court's attention that the best interest of a child in this case is not only limited to not suspending her, as the applicant's case suggests, but it also includes teaching her accountability, teaching her that with every action there is a consequence. Teaching children accountability helps to instill moral values of right or wrong even when there's no one watching. We submit to this court that Rose Modal's suspension was in her best interest as it taught her accountability and responsibility. Rose Modal failed to comply with the school policy, and as a result, she was suspended. We submit to this court that the applicant must be held accountable for her actions and that the school's decision did just that. Section 8, Subsection 1 of the South African Schools Act number 84 of 1996 states that the school governing states that the governing body of a public school, that subject to any applicable provincial law, the governing body of a public school must adopt a code of conduct for the learners after consultation with the learners, the parents, and the educators of the school. Subsection 2 states that a code of conduct referred to in subsection 1 must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and the maintenance of the quality of the learning process. And subsection...
Can I ask you this question? You're dealing with Rose's suspension, correct?
Yes, my justice.
Now, at the time that Rose had been suspended, the school had already acquired the information that Rose should have given them, according to you, correct? They'd acquired that information by going into her cell phone. So, at the time of her suspension, whatever means were used, the information had been obtained, correct?
Justice, I did.
At the time she was suspended, the school knew the identity of the father, correct?
Yes, my justice.
They found that out. And they also knew that Rose was in a consensual relationship with Samuel, correct? They would have known that from looking at her phone.
My justice.
So was the suspension simply not vindictive and just to punish her? Because there was no need to get any more information. They got all the information that they needed. What do you say about that?
My justice, I submit to this court that the school had to suspend Rose Modal as she failed to comply with Section 6.3.4 of the Denga High School Pregnancy Policy. The section, Rose Modal is obliged to comply with the school policy as is stated by the Schools Act, and she failed to do so. Therefore, the school had to suspend her. As it pleases the court.
Could I ask a follow-up question, because it's about exactly what you're talking about? Do you have Section 9 of the Schools Act in front of you? It deals with suspension and expulsion from school, and it says, subject to this Act and any applicable provincial law, the governing body may, after a fair hearing, suspend a learner from attending the school. Did Rose have a hearing before her suspension?
My justice, we submit to this court that the main purpose of a hearing is to let both sides of the story to be heard, to let Rose Modal defend herself from the respondents. We submit to this court that Rose Modal was given a fair chance to defend herself at the counseling session that the school organized for her, and at the intervention that was organized for her with Ms. Mashapa and the principal, where she was asked to disclose the identity of her unborn child's father, and she refused. We submit to this court that a hearing is equal to the counseling session and the intervention that were given to Rose Modal. She was given a chance to state her side of the story. She was given a fair chance to defend herself, and she still refused to disclose the identity of her unborn child's father. As it pleases the court.
Counsel, Counsel, can I ask you this? We're talking now about a fair hearing. There's nothing to suggest that her parents were called to say that they know about the sexual relationship, they know that it's consensual. Would a fair hearing in a situation as serious as suspension include not only the person testifying or being counseled, but any other persons? Should a fair hearing allow other persons to come in and give their views so that a decision is taken on all the facts?
My justices, we submit to this court that Rose Mudau's educators act in local parentage of her. They have the responsibility of ensuring her safety and well-being when she's within the premises of the school. So we submit to this court that the hearing, that the counseling session and the intervention that were given to Rose were fair in the sense that the school, her educators, which are her primary guardians when she's within the premises of the school, were present, and that she was given a fair chance to defend herself, if it pleases the court. My justices, subsection 4 of the South African Schools Act number 84 states that nothing in this act exempts a learner from the obligation to comply with the code of conduct of the school attended by such learner. The school governing body is empowered by the Schools Act to determine school policies. However, the implementation of such policies requires a buy-in from the parents, learners, and educators of the school, which there was in this case, which makes the Denga High School pregnancy policy enforceable, which essentially means that all learners of the school are obliged to comply with the policy. We submit to this court that Rose Mudau was obliged to comply with the school policy as is required, as is stated by the Schools Act, and she failed to do so, which resulted in her getting suspended from the school. My justices, the purpose of a school policy is to create structure and functionality in schools, to make schools a productive and safe environment for the learners. Policies are implemented to help schools establish rules and to create standards of quality for learning and safety, as well as expectations and accountability. We submit to this court that the school acted in terms of law in relation to Section 8, Subsection 1 by adopting and implementing the policy. However, Rose Mudau's failure to comply with the school policy threatened and disrupted the main purpose of the school policy, which is to ensure the well-being and the functionality of the school, and therefore she was suspended. According to Section 9, Roman Figure 2 of the Children's Act 38 of 2005, when determining the best interest of the child, you need to look at the nature of the personal relationship between the child and any other caregiver or person relevant in those circumstances. We submit to this court that when Rose Mudau is within the school premises, her educators are her caregivers, as I have stated before. Her educators act in local parentage of her. They have the responsibility to ensure her safety and well-being for as long as she's within the premises of the school.
Sorry, Counsel, can I just attest the submission that you're making? You're almost suggesting that as long as she's on the school premises and involved in educational activity, her educators are her parents, in effect. Does that mean that her biological parents or her legal parents then are excluded from any decisions that might be taken with regard to Rose's well-being?
No, my justice. What it means is that seeing as her educators are her caregivers when she's within the premises of the school, they have the right, they were well within their rights to determine what Rose's best interests were at that point. They were well within their rights to determine and to take the decisions that they made at that point, if it pleases the court.
To the exclusion of their parents? Are you saying they were entitled to do that without establishing from Rose's parents what their views might be?
My justice, while we recognize the fact that Rose Mudau's parents could have been called to the school, we also want to submit to this court that we also like to remind this court that, as we previously submitted, Rose Mudau's educators are her caregivers when she's within the premises of the school. They have the legal obligation to ensure that she's safe and sound. So we submit to this court that the decision that they made was well within their right.
Could I just ask you this? How fair could it be to have the teachers, who are the ones and the principal who actually suspended her, took the decision to suspend, also at the same time to be expected to be her guardians. It's like being the prosecutor and the judge, isn't it?
My Justices,
In your own case.
My Justices, we'd like to submit to this court that even parents are both the prosecutors and the judges when raising their children. They have the responsibility of making sure that discipline is instilled on their children, and that is the part that the school and the educators played in this case. They had the responsibility of making sure that Rose Mudau understands the seriousness of the matter, and at the same time still receives disciplinary, at the same time she still is disciplined for her failure to comply with the school policy, if it pleases the court.
Thank you. I think there are two more questions. Justice Variava and...
Thank you. Counsel, do you agree that pregnant learners also have a right to a basic education?
Yes, my Justice.
So, by suspending the learner, are you not denying her her right to basic education?
No, my Justice. I'd like to bring the court's attention to Section 36, Subsection 1 of the Constitution, which states that the general requirements for the limitation of any right is that it may only be limited in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. We, as the counsel for the respondent, submit to this court that the limitation that Rose Mudau's rights were not violated, but were instead limited due to a plausible and justifiable reason, her failure to comply with the school policy. My Justices, we'd like to submit to this court that the limitation clause says that
Sorry, there's one more question for you.
There must be a limitation and...
Oh, sorry, are you still busy answering that question?
Yes, my Justice.
My apologies.
There must be a link between a limitation and a purpose. We submit to this court that the limitation of the applicant's rights to education and freedom of association in this case completely promote the purpose of the limitation, which is to teach the applicant accountability. And we submit to this court that the purpose of the limitation in the applicant's case is legitimate and justifiable, if it pleases the court.
Thank you, Chief Justice. I think Justice Variava asked my main question, but there is a follow-up question based on your argument that you've just made now. You've referred to limitations, and Section 36 talks about a law of general application being the instrument that's necessary in order to make provision for the limitation. Can you tell me which law that you are relying upon here to justify the limitation or to set out the limitation? Are you referring to the Code of Conduct? And can you tell me, would you say that that is a law of general application in this instance?
No, my Justices, we're referring to Section 28, Subsection 2, which talks about the best interest of the child. We submit to this court that Rose Mudau's the limitation to Rose Mudau's rights was in her best interest.
Despite the fact that it's taking her away from school and therefore interfering in her right to education.
My Justices, we'd like to bring it forward to the court's attention that Rose Mudau was only suspended for 5 days. We submit to this court that the 5 days that the school suspended Rose Mudau from is not going to have a huge impact on her academic life. It's not going to make her fail, my Justice. The 5 days that Rose Mudau was suspended from school was for the mere purpose of teaching her that with every action that she takes, there will be a consequence, to teach her that she must comply with the school policy as is required by the Schools Act, if it pleases the court.
Thank you, Counsel.
Thank you, Counsel. Thank you for your submissions. We also just heard that in those 5 days, Rose was unable to participate in the National School Moot competition. But maybe she comes here next year with a baby. Thank you for your submissions.
My Justices, I'd like to request 1 minute from this court to finish up my prayers. We, as the counsel for the respondent, respectfully and humbly pray for this court to firstly rule that all the actions that were taken in submission that we have brought forth were in the best interest of the child. Secondly, to declare that Section 6.3.4 of the Denga High School Pregnancy Policy is not unconstitutional. Thirdly, to declare that the search of the cell phone and the processing of the information retrieved from it do not violate the learner's rights to privacy in terms of the Constitution. Fourthly, to determine that the school's decision to suspend the applicant was not unconstitutional and that was in her best interest. And finally, to rule that the school's decision did not violate the applicant's rights to freedom of association and education in terms of the South African Constitution. If it pleases the court, I'd like to take my stand. I'd like to take my leave.
Thank you, Councillor. Applicants in reply, 2 minutes each. Are you going first, Ms. Francis? Okay.
As it pleases the court, I would like to submit our rebuttal for the counsel of the applicant. Firstly, we'd like to state that the Code of Conduct does not state anywhere that the information of the father has to be disclosed. It just states that careful attention has to be paid to the identity of the father. Secondly, the actions of the respondent was not in the best interest of the child, as Ms. Mashapa was known to partake in gossip, and therefore we see this as satisfying her tendencies. Thirdly, we feel as if the hearing was not fair on the applicant's behalf. As stated by the respondent, she is a minor. Therefore, why was the parents not permitted or informed of this
Do you
meeting?
accept that there was a hearing at all? Or
There was no fair hearing at all.
there was no fair hearing or there was no hearing?
There was a hearing, but not a fair official hearing.
Where was the
with
hearing?
Justices. At the school in the principal's office.
Okay.
4, we can see the actions of the respondent as a direct abuse of power, as they disciplined the applicant on means whereas she was not in the wrong. The fifth we submit is that, are we to assume that one policy by a school, an unconstitutional policy, overrides 3 rights, as we feel as though these rights weren't just limited, they were restricted and violated. The last point we have for this is that the school was not acting in local parentis as Ms. Mashapa was not acting in the best interest of the child. Respectfully submitted. Thank you, Honourable Justices.
May I just ask one question? The respondent argued that it was a justifiable limitation for them to gain access to her details on the cell phone regarding who the father was. What do you say about that?
We submit as the counsel for the applicant that the actions taken was a direct infringement of the invasion of privacy, as this was covered up as a means to counseling, yet Ms. Mashapa went behind the applicant's back to retrieve such information by going through her social media as well as personal conversations.
Thank you.
Good. Thank you, Ms. Francis. Ms. Ngubane? Okay, you covered. Oh, just one. Good. Good. Thank you. Then we've considered, or we have heard all your submissions. We've also read your heads of argument. This is a difficult case, so we're not going to deliver an extempore judgment, but we'll adjourn for a few minutes to consider the submissions.
Colleagues, can we please settle down? The judges are ready to enter the courtroom. If you can just settle down. We're giving you 45 seconds to settle down.
All right. Our judges are ready to deliver judgment. You may be seated.
Okay, we indicated to you before we adjourned that we will deliberate, and we had some fruitful deliberations. But before I give you formal feedback on that, I thought we just wanted to share with you the reading of the preamble was a special moment, I think, in this court this morning. It was a special moment because if we ever forget, it reminded us of what our Constitution stands for, and that it's just not words in a book, but it's something that we must all try and live by. Respect for each other starts with how we as colleagues talk to each other, goes on to how you as young people relate to each other, in particular people who are different from ourselves. And that's what living in a diverse society means. But it was even more special for Justice Keatley, who's sitting on my left, because she comes from Umtata High School, and she was the head girl in that school in, she said I can mention, in 1979. And so it was a special moment for her that the young lady, where is she? Who recited it is from the same school as she is. So thank you for that. With regard to the hearing that we concluded this morning, we were all unanimously impressed by what we heard. The quality of the research that would have gone into the submissions must have been of a high quality, and we are mindful that in all of this, you are all still at school. None of you would have had any opportunity of legal training. None of you would have had any access to acquiring advocacy skills, and the oral submissions that were made were of a very high standard. Clearly, you would have had the opportunity to have sort of practiced what is written in your script. But what you couldn't practice was the questions that the court then put to you, because you would not know what kind of questions would be coming. You could maybe generally try and figure out the broad areas of the questions, but the questions that came were very direct and very specific. And we were impressed by the manner in which you were able to respond to those questions. And let me just say a word or two about that, because when you appear before a panel of judges and they ask you questions, it really means that they have some concerns about the issue that you're addressing now. And so the questions are not just asked out of curiosity or to trap you. They genuinely asked because the court has concerns about that issue. And as counsel, you must immediately recognize that, hold on, my ability to get a favorable result in this case is in part dependent on how I respond to those questions. But you did well, because you listened and you responded. and you were willing to leave your script, as it were, because the answer wouldn't be found there. But not all of you. Some of you felt the comfort and the security of the script, and we can understand that. But alas, you might not find the answer there, and advocacy requires that you sometimes have to leave what you've prepared and listen carefully and to engage the court. Sometimes in the question that was put to you, there was a hint as to the possible area of response. It was what one of my colleagues said, a lifeline. The court gives you a lifeline. And if the lifeline is given to you, don't throw it back. Hold on to it and take advantage of it. And some lifelines were extended this morning. Just some things about language, and again, this is something that will happen in the fullness of time. Some of you argued that the provision was highly unconstitutional. Now, it's either constitutional or it's not constitutional. So if you say it's highly unconstitutional, it's not going to really make a difference in how we see the matter. I heard a phrase like, the applicants strongly believe. So we're not really interested in what you believe in. We're interested in the strength of your submission. So you could say the applicant submits. Because ultimately, this is not your personal views that you're articulating. You're submitting an argument on behalf of your client, on behalf of Rose in the case of the applicants, and on behalf of the department in the case of the respondents. But overall, you did very well. On a Monday, the council who appear and who stand where you stood today, and they get paid on Monday for doing what they have to do. And you did it today for free, for the love of the Constitution. And I must say to you, and I don't say this flippantly, I think many of the justices who sit here believe that some of the arguments we heard today are of a quality that we can expect in our courts. So you did so well that you were able to rise to the level of people who've had 6 years of training that you've never had. And so that must augur well for you, but for the legal profession in our country, and also for the Constitution, because it says to us what the enormous potential is that exists in our society. And when the Constitution commits itself to freeing the potential of each person, then if you wish to choose a career path in the law, then today is a wonderful demonstration to all of us that it's something that can bring you great joy and great satisfaction. And the profession, the legal profession, is a wonderful profession because it brings you right into the center of what the society we live in is about. And the Deputy Minister and I might disagree, and we might even agree where the courts play too great a role in defining our society. But whatever the outcome of that argument is, it's an important role that we play every day. It's just not about making decisions. It's about impacting on the quality of the kind of democracy we want to have in South Africa, and the kind of society that so many people lived for and so many people gave their lives for. And that's what the law is all about. At the end of the day, shorn of all its technicalities, it's about the quest and the search for justice. So well done. And now, finally, let me announce what I've been paid to do. The difference between the two teams was a very narrow one. And we recognize that the facts of the matter may have made it slightly easier for the applicants, because the facts favor the applicants. But we took that into account. We took it into account in considering the quality of the arguments that were made. Even though the respondents had the facts not always on their side, the manner in which they responded was something we had to take into account as well. And in conclusion, we found that by a relatively small margin, the winning team were the applicants. we then had to determine the winning oralist for today. We're mindful that you may have been through preliminary sessions, but at the end of the day, it came down to a choice, and again, a very, very close choice between two oralists, one from the applicant side and one from the respondent side. In our view, both of the persons who sort of made it to the final two did remarkably well in how they stood there and engaged with us, were creative in finding answers when none appeared to be on the horizon. I didn't know sometimes how a particular question was going to be answered, but an answer came. It may not have been the correct answer at the end of the day because you can't do better than the facts that you have. But it was a valiant attempt to say, well, with the lemons that you gave me, I'll show you I will make lemonade with some sugar in it as well. So that was very good. And there was quite a difference between the last two people. One was a bit more quiet and subdued, the other was more passionate, but that's fine, because that's the nature of the game. You bring your personality out when you stand there and argue on behalf of your client. At the end of the day, by a very short head, we determined that the winning oralist for today is Miss Jessie Francis. Well done, ma'am. And Ms. Puye, may I say that you did remarkably well today. We realized we could sit here until 3 o'clock, and we were not going to knock you over. You were going to stand your ground, and you were going to make your arguments, and you were going to find submissions, and so you can be very proud of what you did as well today. But as well to the rest of the team, because even those who didn't make oral submissions today would have been involved in the research, in the planning, in the preparation. So all in all, I thought it was a well-spent Sunday morning for all of us, sitting in this historic venue and listening to the voices of the future. I just want to thank the organizers again on behalf of all the justices for putting this together. I have a particular bias in this. I was the chairman of the Human Rights Commission for many years, and I feel particularly proud that the Human Rights Commission, together with the Department of Justice and Constitutional Development and the Department of Basic Education, have continued with this important event. So thank you very much, and I think we have nothing more to say.
All right. This court is adjourned.
Alrighty, thank you very much. You may be seated because we just have 2 last-minute items. We just need to do the prize giving, and then we'll do the vote of thanks. But as I'm told, I just need to wait a little bit regarding the prize giving. You'll just indicate to Rahula when you're ready. But I just need to make a few announcements. The first thing is that we are running a little bit behind schedule, and as a result, I've been requested to just ask that when we finish, when we say Amen, we go outside in the foyer, and you'll find that there will be lunch that has been arranged for the learners. So we ask the adults who are present today to just allow the learners to just get their snack first, and then the adults would follow, so that we just make sure that we feed all the learners. We don't want to have non-feeding. We deal with a lot of non-feeding already in school, so we can't also deal with it in court. So the other thing is that because we're running behind schedule, you are requested to really do not loiter. Just get your food and run straight to your shuttle so that you can be brought back Otherwise, some of you will miss your flights, you'll miss your buses and everything else that you are traveling with or on to get you back home. So don't loiter, don't socialize, just eat and go. Joyce, Rohula, are they still bringing the continental pillows? I do want us to save time as far as possible. Can I, in the meantime, is it okay, Acting COE, if I ask you to render a vote of thanks in the meantime? Yeah, I think we could do that rather than just having a vacuum. Can we request then the Acting CEO of the South African Human Rights Commission, Ms. Chantal Kisun, to just come and render a vote of thanks? Ezandleni bo.
Hello, everybody. What a quiet room. I thought the tension was over. Can we hear a big hello? Thank you so much. Just a few quick words. The Human Rights Commission and Department of Basic Education, the Department of Justice and its partners view this moot court and the ones before it as potentially one of the most exciting platforms to raise awareness across school communities in South Africa, wherever these communities may be. Raising awareness about our Constitution, the values it advocates, is an effort needed more than ever in our country today. The vision of late Professor Christoph Haynes for a national schools moot court competition took shape in 2011 through the Center for Human Rights at the University of Pretoria, the Department of Education and the Department of Justice and Constitutional Development, together with the Foundation for Human Rights. He would no doubt have been ecstatic today. In 2019, when the Center handed the project over to the Human Rights Commission, the Commission took it on as a special privilege to lead the competition as its flagship human rights advocacy project. Tertiary institutions across the country since then have become a part of the project. The University of Pretoria, through the Center of Human Rights, has continued to give incredible support to making this project a success. I include in there Univen, which has more recently joined the team that brings this project together. The National Schools Moot Court competition has grown from strength to strength since the late Prof. Haynes and other founding partners first championed it. The first word of thanks, therefore, goes to the late Prof. Haynes and the stalwarts who supported him, the Deputy Minister of the Department of Justice, the DBE, and the Foundation for Human Rights. Indeed, the competition has grown in strength and stature over time, thanks to the efforts of a wide body of people who believe that awareness of human rights and critical thinking about human rights are one of the most powerful ways in which to transform our society into one where respect for a culture of human rights prevails. In 2020, our national finalists participated in the first global moot court competition, participating with a number of different countries for the first time. The 2020 team brought the global trophy back home, making us all tremendously proud of their efforts and boding well for this program. The Commission has enjoyed unstinting support for the National Moot Court competition from partners in the Department of Basic Education and the Department of Justice, as I've said, from its inception, who believe in stimulating active interaction between learners and the Constitution, which governs us all from an early age. The Commission therefore thanks the Department of Basic Education and the Department of Justice for consistently honoring this event, and in particular Deputy Minister John Jeffrey, who to my own knowledge has never missed a final and has enthusiastically thrown the weight of the Department of Justice behind the competition, regardless of the demands on their time. We've held now the Moot Court in a number of platforms. During COVID-19, the Moot Court was held remotely. And yet, despite this time, justices of our court agreed to preside over the National Commission each time we asked, lending their august presence to the proceedings. Members of the judiciary have continued that tradition of support today. Usually, advocates have to jump many legal rules before they are able to access this court. It seems the court is biased, as it has waived all of its many rules to preside on a Sunday here today. We extend humble thanks to Judges Kovarji, Knightley, Victor, and particular thanks to Justice Colopin for prevailing and presiding over this panel from the highest court in our country. And we appreciate very much that they have taken time out of their rigorous schedules to support learners and to support this competition. Your presence has elevated this competition to one which will forever be etched in the minds of us all. Thank you, Justices. Our partners from Cliff Decker through Ms. Jackie Cassette, human rights experts, Prof. Ann Skelton from the University of Pretoria and Leiden, and Farnaz Bravia from Section 27 have also walked this journey with us and presided as judges today. We appreciate, in addition, the adjudicators of the preliminary rounds, who included a broad range of legal professionals in private practice. We thank donors and sponsors for in-kind contributions, the law firm Cliff Decker Hofmeyr, Freedom Park Trust, Study Trust, and Old Mutual. Together with DBE TV, your support has been invaluable to the Commission, to the partners, and certainly to the learners. Appreciation is also expressed to Commissioners of the Human Rights Commission for their leadership and support, to officials of the DBE, including the DG, provincial and district coordinators and educators, the Department of Justice, DG, state law advisors, and the South African Human Rights Commission team for their efforts, sleepless nights, and belief in our learners. To parents and learners, you've been nothing short of amazing. We hope you will continue to promote human rights and wish you well. A very humble thanks to you all. In closing, I want to say that the problem statement you interacted with is a reality, and just one reality of the many dimensions of challenges which face our society today. And we look at the context where over 300 reported teenage pregnancies were documented in the last quarter. We look at the context of COVID-19, abiding poverty, deaths of minors in taverns, in pit latrines, and the constant threat of load shedding and its reality. In this context, it's clear that learners today face a host of challenges which impact on education. Despite these challenges, however, your voices have rung out clear as a bell today in this very auspicious chamber. Clearly, all of the schools which participated in their districts through the provincial rounds, and now here at the national levels, are a testament to your resilience, your commitment, and awareness of human rights. For now, you may be only a small group of winners, but your formidable talent, courage, and sheer amazingness bodes well for us, a country of winners. It means respect for human rights will always resonate with you, wherever you go, and whatever discipline it is you choose to follow. We therefore express immense gratitude to you, your parents, your educators, your guardians, and wish you every success with the upcoming matric examinations and for the future. A real sincere and hearty congratulations. We are looking forward next year around the same time through the Commission to convene again the National Moot Court competition, and we are exploring as well opportunities to again participate in the Global Moot Court. We will keep all schools notified of the developments on this through the DBE. Congratulations all again, and thank you very, very much. Enjoy your Sunday.
We thank you, Acting CEO. Here's your phone, ma'am. Just before I go through and check who's the father of the child. I thought there's no way, Justices, that I'm leaving this room without sitting here. That's why I changed positions. So let's give over to Joyce to then do the handover of gifts and awards. Oh, okay. I thought maybe they're standing for too long because they're used to sitting down a lot. You can do it, it's fine.
Best overall essay is from the Eastern Cape, from Mida Secondary School, but they are not here. But the provincial coordinator is here for Eastern Cape. It's Shamuli, Shakia, and Kim Sibanda from Mida Secondary School. Can the coordinator please? You can come and get the certificate from the judges. And that school was also the best applicant essay. It's also Mida Secondary School. So you can go to the justices. They say to the back. Please move towards the back a bit for the picture purposes. And they said, please remain standing where you are. Please remain standing. Best Respondent essay, they are here. It's Mutata High. It's Sange Dingezweni and Avuswa Malamlela. Trophy, please. The essay and the trophy. Two of them. Two of them. Each one gets. Please pause with the justice. Avuzo. Please pause with the judge. Please pause with the justices for a picture. The other one side, the other one side. Yeah, yes. And the educator, the chaperone. Best oralist, Jessie. Jessie, which school? Huh? Wynberg High School in Cape Town, Western Cape. Roller? Trophy, please. Oh, she has. The runner-up team is the respondent team. 4 of them. They have to be 4. Okay. Runner-up team, the respondent. Rohula, please advise me the schools again. Mpapuli High in Limpopo. And the other school? The other school is Goldview in Northwest Province. So, Limpopo and Northwest. Thank you. And the winning team are the applicants. Please go. So that is Nsikayetu in KZN and Wynberg Girls High in Western Cape. Oh, it has not yet been completed. All right, we will complete them. Yes, I think they were still waiting for the names. And the yes, they can hand them over to us, including the trophies as well, because they still need to be inscribed with their names. And the chaperones, the educators, the coaching in their coach. As well as perhaps the other judges as well for the winning team. Please get into the picture. I don't know who arranges them. Ladies and gentlemen, the 2022 winners of the National Schools Moot Court program. Thank you. Thank you. 2 minutes, Justice. 2 minutes, Justice Kolapen. I know I promised you. I still have 2 minutes. With your indulgence. Yes. So the learners, they can leave. And we have the most improved, you can then put yourself again, the most improved province for the 11th edition of the National Schools Moot Court is Northwest Province. No, it is your educators, the coordinator for Northwest. Oh, Ntate Senso, I think he's not with us. Oh, they will be represented by the educator from Goldview. and the best coordinated province for the entire round in observing the rules of the competition to a T without any problems whatsoever is the KwaZulu-Natal province. Mayor Fikile Pidlomo, she's actually a stand-in coordinator for the last 2 years and has done an exceptional job. Please, to the justices. You are supposed to hand it to her, but she's bringing it to you. Right. Thank you. And as tokens of appreciation for the judges for taking time out of your busy schedules on Sunday, a restful Sunday, please check then tag the names inside first. Thank you. Liko, over to you. And Justice Kolapen, I met my target of past 10.
All right, thank you so much. We'll allow Justice, Deputy Minister, and Commissioner to then exit the courtroom. Thank you very much. Oh, and the justices too. And the justices too. Yes, everyone, my apologies. Oh, this side, okay. There is also an exit outside. Yeah. All right, so we've come to the end of the program. I know that I had said that we are running behind schedule, so please just grab your meal and go to your bus so that you are not left behind. Our phones will be off, so if you miss your flight, don't call us. See what to do. Thank you.
Can we please, the winning teams, can we kindly have the trophies for inscription? Please let us have the trophies. There must be 10 of them. Raura, please, the trophies, count them. I need 10 trophies. I need 10 trophies. And the gowns as well. Thank you so much. They are not yours. Yes, they can interview them, but without the gowns. I need the 10 trophies, please. There must be 10.
I'm going to give you 10.
Okay.
The others are in the box.
Okay, I was panicking. Hey.